Good morning, everyone. Today is day two of the deliberations in the Karen Reed case, and I got a lot of questions about the verdict form, so I wanted to discuss, as well as deliberations. All right, count one, second degree murder. The choices are number one, not guilty, or number two, guilty. Very straightforward. There's no issue. It's either yes or no. It's either guilty or not guilty. Page two is where it gets complicated because there's a lot of lesser included offenses. So, because Judge Cannoni, and this is a personal preference, Judge Cannoni is a defense attorney, former public defender. So she always puts not guilty first when it really shouldn't be at the top of the page because it kind of confuses the jury. But as you know, the second charge is motor vehicle manslaughter. That's the most serious offense. If the jury finds that charge has been proven beyond a reasonable doubt, you check that box. But that's not the only charge on that page. There are also what's called lesser included offenses. Lesser included offenses have very similar elements. So if you can only convict for one of those offenses on the second page, you can, since motor vehicle manslaughter or murder two have different elements, you can both convict the same, you can acquit the same, or you can convict one and acquit on the other. That's important to understand because people are thinking, well, motor vehicle manslaughter, it's also a death. It's like, no, there are different elements, two separate charges. What happens on one doesn't necessarily need to happen on the other. So what you can only do on page two, you can only check one charge. So one number. So it's 1 through 5, not guilty, guilty of motor vehicle manslaughter, guilty of involuntary manslaughter, guilty of motor vehicle homicide, felony OUI, liquor and negligence, and misdemeanor OUI. So of those 5 numbers, only one box can be checked. Only one, because it's the 3 lesser includeds are less included of motor vehicle manslaughter. You can't be convicted of motor vehicle manslaughter and also misdemeanor OUI. There's only one thing you can check. So this is where a lot of the people, so I posted about this on Saturday, right before my daughter woke up. I actually thought about bringing her onto the show, but I think she wanted to get her diaper changed or go see mommy or something like that, or just be held by me without a camera. So when you are, so there's a lot of discussion online. It's like, oh, wow, what about this? Like, yeah, misdemeanor OUI is a possibility. So this is where it gets interesting. So the jury could find her guilty of motor vehicle manslaughter. That's it. End of. They could check box 2 over. They could check not guilty over, or they could check box 3 involuntary manslaughter. There's only one. There's 5 options, 5 numbers. You only get to check one, and then like was 0.08 or higher. So that's a possibility, or it's just impairment to be able to prove whether the individual was under the influence of alcohol. So that's where it gets interesting, because in the first trial, as far as I could see, I was shown the verdict form. There is no misdemeanor OUI in the first trial. So that's where it got interesting, and people picked up on this over the weekend. Because content creators and supporters of the defendant wanted to get to have that moment on the courthouse steps, vindication. I'm a victim of a cover-up. Thank you for the jury. This, that, and the other thing. So now, that could have happened in the first trial. If they had put that misdemeanor OUI in there, it's possible that the parties, not knowing what it actually truly meant, the juror members, might have been like, well, she was drunk. I don't know if she hit him, but she was certainly drunk. We could all agree to that. They could have been like, yep. And if they were actually truly decided 12-0 on charges 1 and 3, they could have been not guilty, not guilty. The case would have been done. So you would have got misdemeanor OUI, and there would have been no retrial. And a lot of people are now, a lot of these content creators looked it up. It's like, oh my God, Massachusetts OUI laws are tough. Like, yeah, it's not a slap on the wrist. It would be certainly a lot less than getting convicted of second degree murder, which is mandatory life, or motor vehicle manslaughter. That's punishable by a minimum mandatory of 5 years. So let's just go through page 2 real quickly. If she is convicted of motor vehicle manslaughter as charged, it's a minimum mandatory 5 years in prison, punished by up to 20 years in prison. My guess is if she were convicted of that, Judge Cannoni would give 10 to 15. So it's not like you do 3 years on that. No, Massachusetts doesn't work that way. If it's 10 to 15, you serve a minimum of 10 and a maximum of 15. So 10 years is when you're eligible for parole. Same with murder two. You are there's life with the possibility of parole. And the way Massachusetts sees it is they see a life sentence as 30 years, and you're eligible for parole in half that time. So after 15 years, the defendant would be eligible for parole if she were to be convicted of second degree murder. And now, as to involuntary manslaughter, it's that's where the jury might kind of have issues because involuntary manslaughter is more of a lesser included of murder two. Motor vehicle manslaughter technically fits, but it might have been better on page one. But I don't know if they would go involuntary manslaughter just simply because if you either believe that she did it or there's no collision, I think you'd have to, by sheer common sense, convict of something more serious. Um, so then it comes to what I think is the charge that the jury is going to be looking at. I believe it's number 4, motor vehicle homicide, felony OUI, liquor and negligence. So this is the final charge, the lowest offense the defendant could be convicted of, with them determining that there is a collision and that Karen Reed's vehicle collided with Officer O'Keefe and caused his death. Not saying she intended to do it, not saying she created a reckless environment, none of that. Her car hit him, he died. She was drunk. That's it. That's all that's needed for motor vehicle manslaughter. I'm sorry, motor vehicle homicide, felony OUI, liquor and negligence. But that charge has teeth. That's a minimum mandatory of 2.5 years to up to 15. And again, Judge Canoni is well within her rights to give the same sentence she'd give on a motor vehicle manslaughter, 10 to 15. So that's kind of that second page. The jury is going to have a real hard time getting past. And then, of course, the final charge is just misdemeanor OUI. And I remember David Unetti seeking the lesser included offenses. And this one is one that wasn't there last time. So now it's part of this case because I think the Commonwealth is like, if we can't get anything better than misdemeanor OUI with as perfect of a case as Hank Brennan could have tried, given all the facts, especially all the bad facts in this case, that's all you're ever going to get. It's not going to get better. The jury pool has been too tainted to the point that we're just wasting money and we're just banging our head up against the wall, and it's just not going to get any better. But misdemeanor OUI has teeth. It's not like it would be a slap on the wrist. It would certainly be a lot less if the message it was sending that officer that it wasn't proven that Karen Reed was responsible for the death of Officer O'Keefe. That said, is they still have the civil case, and that's a much lower threshold, one that they should easily be able to overcome with pretty much the same case. But a conviction here, essentially of motor vehicle homicide or higher, guarantees that they can prove the other case, the civil case against the defendant. But it's still misdemeanor OUI is punishable by up to 2.5 years in jail. It's not nothing. The defendant would, since it's a misdemeanor, it's not we'll remand you or you can stay out of jail. What? No, your sentence is done on the spot. So it's either remanded pending sentencing, or you're going to be sentenced on the spot. And Judge Canoni, given all the facts, she's not going to be like, well, I think I'll give you a continue without a finding or just probation. No, she has watched the defendant in court for 2.5, 3 years. I don't see a situation where she doesn't get incarceration, even if that. So when you see people, because if you've seen over the weekend since about Saturday, after I posted this, the narrative online has changed. Now it's talking about misdemeanor. Oh, she wasn't drunk. I was like, whoa, 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 whoa. I thought this was a conspiracy. Now there's no collision. Now you're saying she wasn't drunk. It feels like it keeps changing. And it's like it's been well established. The defendant's own words, as well as the retrograde extrapolation, are strong circumstantial evidence she wasn't intoxicated. Weak pours, like how they watched all the drinks being poured. It's like any rational person would know that that individual was impaired. And with the retrograde, so she can't be convicted of more than one charge. That's incorrect. There are 3 charges. She can be convicted of the first charge, the second charge, or the third charge. First charge being murder two, second charge being motor vehicle manslaughter, third charge leaving the scene of an accident involving death. So that's what. So it's wholly independent. That's only if she gets acquitted or they of second degree murder. If they acquit on that, they can still think of it as three separate cases that were tried together, three charges. Just because you're acquitted of second degree murder doesn't mean you're acquitted of motor vehicle manslaughter. But as we saw from the first jury in the first trial, they kind of put the one and three together because leaving the scene of an accident involving death includes a knowing element. So if she's not convicted of one of the um, offenses that involve the collision, she's not going to be convicted of leaving the scene of an accident involving death. They never talked about the 227 Google search. That was a joke. He said it during open. Alan Jackson said it at opening, and then he just kind of like, well, we're just going to pretend it didn't happen. We're not going to talk about it. Jury picked up on it. He said it. They introduced it. They tried like hard to discredit them, and then they didn't try to disprove it. So that Google search did not occur at 2:27 a.m. And that's their biggest. That was arguably their biggest piece of evidence for this so-called conspiracy. Why do you think so many YouTubers and lawyers are on the conspiracy money? Why risk your reputation? So I think your question is kind of rhetorical, Andrea. So what has happened, and I've said this a bunch, people who rely on this for their business, for their like income. I have a law firm. I have my own clients. I make that money that way. This I do on the side to kind of help, promote myself, but also talk about justice and like making sure that people aren't lying and stuff like that. So they be held to accountability. A lot of these YouTubers, they are too afraid to lose subscribers because these people who are believing this conspiracy, if they don't hear what they want to from the person they're listening to, they're just going to go to somebody else who's saying what it is. And there are YouTubers who know it's not true. They know they are lying. But they are doing so because they don't want to get turtled. They don't want to be attacked by the Free Karen Reed mob. I, on the other hand, don't give a shit. I've had my account hacked. I've had people crank phone call me, leave fake Google reviews, send fake emails, the whole 9 yards. And I just don't care because this is about truth and justice in this case. It isn't about cash and clicks. So when you think about why they're doing that, it's very simple. Follow the money. Like some of these people, they're not saying this conspiracy, people are going to turn it off and they're not going to get 30,000 people watching their stream. They're not going to have 500,000 subscribers. Those people are just going to go to somebody else who knows that it's either I say what they want or they're going to go to somebody who can. Thank you for the sane, rational analysis. I believe that Hank Brennan does not get does. No one will ever. He was broke. Yes, very simple. And that's the thinking with the misdemeanor OUI charge, is that you have the top trial lawyer in the state prosecuting this case, and he did it brilliantly. And if he can't get a conviction, nobody's going to. It doesn't matter. It's just the facts are just too. It's just going to breed too much dispute among jurors, no matter who they are, no matter where they are, and you're never going to be able to find 12 people to agree on anything. So why keep going for years upon years upon years? You don't want to. And I think it's a dangerous precedent that all you have to do is have a lot of money, and then you could just take the jury pool and turn it into a conspiracy. And you could just keep getting hung juries until they just give up. Yes, they trade in integrity for clicks, and that's the truth. And they think that that's going to stay with them. The people who left them and went to somebody else who are talking about truth, they're going to remember that. And those same people. So I was on the prosecutor's podcast, Legal Briefs, last week. I think I posted it on Twitter, but you can listen to it when you get a chance. The next step is the Brian Koppenberger case, the quadruple homicide out of Idaho. What are those content creators going to do? That evidence is 10 times more concrete than even this case was. And this is very strong. Are you going to also have to argue conspiracy And it's like, that's probably what they have to. Like the people who were telling me about how Richard Delphi was framed are the same people telling me Karen Reed's framed, and the same Cottenberger was framed, and that Luigi Mangione was justified in murdering the guy in cold blood. Um, you got hit very hard for killing someone via vehicle. I agree. I wish after the second hung jury, the judge would just step in and rule a verdict. That unfortunately, it's not how it works. Um, it's you're entitled to a jury trial in this case, and as long as jeopardy, double jeopardy, it doesn't attach, the case goes forward. So double jeopardy, just so you know, it's not just. Oh, so I think this is. Well, I'll wrap it into the verdict form. Double jeopardy just doesn't mean if you've been tried and acquitted. That's not the only case double jeopardy attaches. It also attaches when you've been tried and convicted of a crime. So if you've been like I said last week, Ashley Judd, double jeopardy. You've been convicted of murder and you can't be tried and convicted of it again. That's not how that's doesn't work that way. Um, but also the one thing that most people don't know, and a lot of these YouTubers who don't practice criminal law and just pander don't know, it also applies to a situation where you're convicted of a lesser. So let's go back to motor vehicle manslaughter. You saw that has not guilty as number one, and then there's 4 charges underneath. Those 4 charges, number 2 is the most serious, motor vehicle manslaughter, and the 3 beneath them are lesser included offenses. If you get convicted of a lesser included offense on that charge, so if the jury checks box 4, motor vehicle homicide, that precludes a retrial of involuntary manslaughter and motor vehicle manslaughter, because those, by not acquitting, by not convicting them of those charges, you are by that fact also acquitting them. So acquitting her, I should say. So if you click motor vehicle homicide, you are essentially saying not guilty of involuntary manslaughter, not guilty of motor vehicle manslaughter. That's important. And most people, you don't hear that. So that's why people are like, what is this on verdict form? And people talking about misdemeanor OUI. It's like, David Yenny asked for the lessers, and you get all the lessers in that case. You don't get to pick and choose which ones. And the Commonwealth is smart enough, Hank Brennan's smart enough to know that there's more than enough evidence to get a conviction. And the image of being able to rob the defendant of that vindication interview on the courthouse is a real strong image. I mean, like she may not be held in this courtroom for this crime, but she is certainly going to go to jail. And she's certainly going to be on probation and the whole 9 yards. And I think the victim's family knows if Hank Brennan can't get it, nobody's getting that conviction. And that's really unfortunate that the defendant, with using a blogger and this army of social media trolls, created this jury pool that's completely infected. Because think about it, you turn on the news anywhere. You can't go anywhere without that case. What about this conspiracy to harass witnesses? I thought they brought it to a grand jury and they declined. I think, if my memory serves me. I fear the ramifications of a hung jury in this community, continued harassment. Yeah. If they come back hung across the board, it's tough not to retry again. Because then you're not just going to allow these witnesses to, you can't incentivize a defendant to do what they're doing and essentially enable them. And you think about what happened with the blogger, where his case was tried and he was acquitted by the judge, which was smart move on his part, simply because the jury would have convicted him in 20 seconds. But if they're no longer witnesses in the case, then it creates a gray area for potential harassment. I hope there's no more harassment when this case is over, but I'm not naive enough to believe it's not going to happen. If they notify the verdict is in, she's guilty of something, there's no way she's getting acquitted. It depends on the timing. I can't see. So this is important, actually, doing deliberations. There were people who said we were going to have a verdict on Friday, one of which I had to privately message and be like, you said the same thing last year. And they responded with the fire emoji because they did. And I called them out for it. And a lot of people are like, oh, it's going to take 10 seconds. It's like, do you practice criminal law? This is a 31-day trial. This isn't a this wasn't a 2 day this wasn't a 2-hour DUI trial. This was a murder case. Um, so what I know about this is probably if we don't have a verdict today. So if they spend a good 7-8 hours deliberating, and there's a verdict, my window, knowing criminal cases like I do in high profile ones, I think the window for a guilty verdict is either later today or early tomorrow. Meaning that if they come in and say 10 a.m. tomorrow, so June 17th, 10 a.m. to 12 p.m., that's when I would feel that would be kind of a guilty verdict situation, because what juries like to do is that at the end of a day of deliberations where they think they're close to it, they go home, they sleep on it, and then they come back and they're like, how do you feel now? And usually they're like, I'm still in the same place I was yesterday. Guilty, 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 or not guilty. But after that, if we go into past day 3, then again, we're in hung jury territory. And then at best, it's a compromise verdict. But after Tuesday, it's unlikely you're going to get an acquittal. So if an acquittal is to happen, most likely, probably 75% chance, it needs to happen before lunch or early afternoon at the latest. After that, I just think people are not going to. The jury is like, well, there's too much evidence. And the first time, yes, the understanding is they didn't have her phone evidence the first time, and with the jury, grand jury for witness intimidation, but we go back and get it. The problem with the grand jury is that if you go and you don't have everything for the same charges, double jeopardy actually attaches in a grand jury. It ends. So if you ever seen the show Defending Jacob, where they're doing like it's like an overarching grand jury. Grand jury is if they decide no bill, case is over with. You can't charge it. So let's take a look. Most YouTubers are not practicing attorneys. No, they're not. And the ones that are, I saw one spent Father's Day talking about how no jurisdiction in Florida would have brought this case, no state attorney. I was like, no, I have other things to do with my life than to be like, this guy is an idiot. And now he's just beyond pandering to say that because a cop is dead. So if I had a Sarasota sheriff's deputy was hit by someone and all the evidence pointing towards her, including the digital evidence, the forensic evidence, the physical evidence, they would never be that relationship between the state attorney's office and that sheriff's office would never be the same. I look for the jurors to be quicker because how long this trial, people want to go back to the lives is long. So that is the people on this. That's an interesting point. The people on this jury know what the ramifications are of this. They know that before they even were on this jury, they probably saw facts about this case. They saw it being posted. They didn't form an opinion, so they said, but they definitely saw about it. So they know what's going to happen with this case. If they were to convict, they know that of murder. They probably know the defendant's doing life. But I feel that, so this is something I thought of during Hank Brennan's closing. I don't even know if he realized what he was arguing. Is he talked about they broke up in the car. They had a fight. They got out. And her in anger backed up and blasted him. And then went home and made those angry phone calls. That was what the attorneys say isn't evidence. But if you accept that, an argument could be made to the jury that it was a heat of passion, which it wasn't, but a jury couldn't understand as much. So the evidence of second-degree murder actually lends more towards a motor vehicle manslaughter charge because it's a heat of passion. So it's possible that I picked up on that. I don't know if the jury will. They might, hearing that, get their that might be enough for them to kind of eliminate the second-degree murder, even though they don't need intent to kill. That's murder 1, and people are trying to screw up intent, and it's like, that's not required. just creating a situation that she knew could lead to serious bodily injury or death. Backing up your car, hitting them with it, that's creating that injury. What happens if there's one holdout can then came to the jury to review? So this is interesting. So usually when they do deliberations, the alternate is excused. Like here in Florida, we pick 6 jurors for a felony, 12 for a death penalty case, and then there's 1 or 2 alternates, depending on the charge. And when deliberations start, that alternate juror is excused. But here, they're hanging out in the courtroom because if they come back and one of the jury's like, hey, we need to talk to the judge. This juror very clearly was not truthful and is secretly an FKR person, and they're not refusing to deliberate. An argument can be made that individual could be bounced from the jury pool. So I don't know if they will. That would definitely create like a humongous appealable issue, but it's also very possible. That the cousin is on the jury. Yeah, I know. To vote. Yeah, I pray there isn't a plan. Somebody on X says their cousin on the jury and they started a month ago to vote. No. God. Oh, you gotta love Twitter. Do you think the jury is looking at social media or no? No, they can't, because the judge asks them every time. And if the answer is yes, they're gone, because they're seeing things they're not supposed to, and they're seeing opinions. And anytime a juror says that it doesn't affect their ability to be fair and impartial, the truth is it always does. So when you're actually trying a case, and a lot of these YouTubers who are like directed verdict or talking over testimony, they don't actually try cases anymore. And they don't know that when somebody says, I think I can be fair and impartial, the answer is, I want to believe I can be fair and impartial, but I'm not going to be. So I believe it was forwarded to the court, so don't worry. Yes. If she gets convicted, no, she's not going. The judge is not going to allow her to stay out pending appeal. That she gets treated like any other defendant. This is not a white collar case in federal court. This is, if she's convicted of motor vehicle manslaughter, she's treated like any other defendant. She doesn't get special treatment because she's Karen Reed. It's very simple. She'd be remanding pending sentencing if she were convicted of that. The only situation where she would get convicted and walk out is if the judge didn't give her any jail time on the misdemeanor, if she got convicted misdemeanor OUI and got no jail time. Other than that, it's remanded pending sentencing. Anything else would be ridiculous and completely against precedent. What else? So deliberations. I'll discuss deliberations real quickly. If I'm the foreperson, this is what I do. I start the case with, was she intoxicated? That's the most fundamental thing, because it deals. You can start with the charge 2 and go from there. Was she intoxicated? Yes. Going around. Yes. All right. So now she's intoxicated. So that's misdemeanor OUI. All right. Now here's where it gets dicey. Was there a collision? Did Officer O'Keefe's vehicle? What did Karen Reed's vehicle strike Officer O'Keefe, leading to his death? Because we know it leads to his death. So did the vehicle strike it? And if the jury is the foreperson is like, my notes say they had shards of the taillight embedded in his clothing. My note says that the hair found on the taillight is Officer O'Keefe's. And the people were like, oh, it could be the nephew's. Oh my God, don't be ridiculous. How did they get that? That's ridiculous. What, did they go to the kid in the middle of the night, take it off his head? No, it's Officer O'Keefe's head. The problem is you think, what I've realized is almost people watching this case who don't believe the conspiracy almost gaslight themselves. Like, if these people can believe it, are these 12 jurors also not going to? Do you think AJ gave a reasonable AJ's argument started good, and then it just looked like it was written by the defendant. Once it went off on the conspiracy rant and this, that, and the other thing, I was like, okay, this is stupid. If she gets convicted on the lesser, she'll get 2 to 5, 2.5 to 5. So if she gets misdemeanor OUI, so let's just recap, because not everybody was here when I stated it earlier, and I'll think of you a few more questions. I do need to get to a court soon, federal court. If she gets convicted of misdemeanor OUI, it's punishable by up to 2.5 years in jail, county time, whatever you want to consider it. House of Corrections. That's misdemeanor OUI. Motor vehicle homicide, felony OUI and liquor and negligence is a 2.5 year minimum mandatory. So she gets convicted of that, she has to do 2.5 years, and that's punished by up to 15. And I think that the judge would give her probably around 10 years. I said 10 to 15, but probably 10 years for that. Motor vehicle manslaughter is a 5 year minimum mandatory, punished by up to 20 years. And she get convicted of that, I'm pretty safely assuming she'd get double digits. And of course, murder 2 is life with the possibility of parole. Heard Yannetti arguing over the form is a possibility. Well, maybe David Yannetti was watching the stream on Saturday and they just realized, but what do they want to put? Not guilty? No, that's not how it works. You don't get to have not guilty on 20 pages. Are you not guilty of this charge and every charge on the page? It's very simple. And if she's not, because that's what they is, because then they can argue, oh, they don't know what they're doing. Because you know what David Yannetti and the defense is thinking. If they acquit on one of the charges, that they could say that they acquitted for all of them and create an appellate issue. It's bullshit. Excuse my language. Yes, John O'Keefe's life is worth more than 2 to 5 years. Absolutely. And that's the unfortunate reality is no matter what sentence is imposed, it's never going to bring Officer O'Keefe back. It's never going to fill that void in Peggy O'Keefe's life, no matter what. It's just, that's how the law is created. And that's the unfortunate reality. Argument that he was in the house. Oh my God. When Alan Jackson tried to argue the glass was from the house, I was like, you had a relatively strong closing argument. And then you go full, he went into the house, even though there's no evidence of it. So, and the glass that the defendant herself stated was hers in the video, you try to say was inside the house? If the jury's paying attention to that, that was the biggest mistake Alan Jackson made. Because if he's saying that tells them that they have no idea. Didn't say she was buzzed. Yes. Yeah, and she wouldn't take that highway. Again, misdemeanor OU, unless there is some person, some FKR who will never convict of anything, not even jaywalking, she will get convicted of something. I think the hair is from the arm, just in my opinion. Yeah. Whatever the hair is, the DNA matches John O'Keefe. And it was like 1 in 80 octillion or something. It's his. It's not the nephew's. It's his. What happened to the defense witness who saw? There was no defense witness who saw John O'Keefe enter the residence. That was promised an opening to try to keep the jury's attention, and it never happened. And the jury picked up on it. So if he doesn't go into the house, his phone doesn't go into the house. His Apple Watch data, there's not one witness. So how does he get beat in the basement? How does he get beat in the garage now? He doesn't. He was hit by the car. The jury needs to focus on the data and evidence is pretty conclusive. Exactly. And that's what, when I said last week during closing, when I talked about closings in a stream, is data, the forensic data, the physical evidence, and the the digital evidence. That's what needed to be focused on. That's what Hank Brennan did. And it's like evidence, evidence, evidence. If she walks, I'm going to... And this is what I say with any kind of verdict. The verdict, she should be convicted of something based on the evidence. But what I know is juries are unpredictable. Every trial attorney, real trial attorney, will lose cases they thought they were going to win and win case they thought they were going to lose. Always. You don't know. You don't know what they found persuasive. You don't know what they're going to focus on. They're doing what they think is right. And based on the evidence, I think she has to be convicted of something. I don't know if they get to murder 2. I think that Hank Brennan still made a very strong argument for murder 2. But I think a part of me thinks that it was to soften the jury up to finding her guilty of a lesser. Like, all right, who thinks murder 2? And it's like, yeah, 4 or 5 of us. And 4 or 5, and the rest of us are like, motor vehicle manslaughter. They go back and forth. And then it's like, Let's just do motor vehicle manslaughter. I'm good with that. Let's move on. If that happens, the Commonwealth will take that. So if you're the Commonwealth, you'll take anything motor vehicle homicide or greater. If even if they hung on 1 and 3, they're not going to retry. If they get her for motor vehicle homicide, that's going to be more than enough for them, and it's just not going to be worth the nonsense that goes along with this case. The timeline and data is just too tight for any possibility. Exactly, and that's what the jury's going to be looking at. It's like how do you frame somebody with a black box that they didn't even have in the first trial? We give Shannon Burgess about his LinkedIn profile and this, that, and the other thing. But he was the one who found it. He gave the data. He's the one who tracked it. Ways. It's just there's too much. And yeah, so what you're going to be hearing is if she does convicted, free Karen Read, people are going to lose it. YouTube people are immediately going to be appeal, Bev, blah, blah, blah. And it's like, shut up. This is due process. The evidence, this should have been the verdict in the first trial, but unfortunately, there were people on the jury who were just never going to convict, no matter what. So I think I'm going to do a couple more. I could see them splitting the baby too. If we're into the end of the day, if we get to lunch tomorrow without a verdict, I have to think we're in compromise verdict or hung jury territory. So if you're the defense, you want a verdict before 2 p.m. because if you believe that it was just this conspiracy, you don't need to talk about it. It was Karen's choice to not drive. Yeah, and that was a devastating piece of evidence. Not once does she call 911. She tries to find him on his own. Not my boyfriend didn't come home. It's a blizzard. He could have got into a car accident on his way home. Why didn't she? She knew where she was. And that the jury is just going to be like, so when they're trying to rip Kerry Robinson and Jen McCabe, they're the ones that actually called 911. Karen Read didn't. She's like, oh, she was giving him CPR. What about before then? I'm still upset over the Casey Anthony. All right, I can tell you this. I knew she was going to be acquitted before the verdict came down. The reason is this: and people are like, the medical examiner. All right, in the Casey Anthony case, the medical examiner could not determine cause of death. In that case, it was important because they were arguing an intentional murder. So it had to be homicide. If they couldn't determine homicide, that's reasonable doubt. So it's either homicide or accidental. That's why she was acquitted. This case is not the same because homicide and accident are interchangeable because he was hit by a car. That medical examiner doesn't know if it was on purpose, doesn't know it's on accident. That's important. The state didn't have a strong case with Kingston, but they have strong evidence in this case. Yeah. That's what the defense wants you to do. They want to say so much, spend your logic. Exactly. That was the whole theme. And I think we're going to end here. Leave your common sense at the door. I will say I did love when Hank Brennan, I literally I think I spit out my drink when he said, look the other way. I was like, oh my God, this is just ruthless. And it is. It's like, look the other way from your common sense and logic. Look the other way from, and that's okay. We'll get to this Casey Anthony thing will be the last one because Jose Baez can help answer that. Look the other way with the digital forensic. Look the other way for the physical evidence. And that was just devastating. Yes. So in the Casey Anthony trial, the other thing was the state did not introduce the phone data, which had Casey Anthony's phone pinging in the exact same area. Jose Baez in his book, when he says, we're waiting the whole time to be hammered with that because that's what's going to sink our case. And they never introduce it. So that prosecutor who tried that case had to resign because if you're a prosecutor and you can't win the big case, you probably aren't going to be trusted to be a prosecutor in the future. But I got to get to federal court. We are in jury deliberations waiting. I will be intermittently on Twitter throughout the day. I may do a show at 5 or tomorrow, depending on what's going on, but I'll let you guys know. Thank you very much. Have a wonderful day.